Here is a fear many families have stated precisely, that the government can simply take a family's home the moment a parent enters a nursing home. According to Medicaid's own federal guidance, that specific fear is not accurate. Medicaid cannot seize a home while its owner is alive. What can happen is more specific, more limited, and more procedural than that. And understanding the actual mechanism is what allows families to plan around it correctly. I'm Michael Bennett. Welcome to Retirement Watch, the channel dedicated to helping you understand the programs and policies that affect your retirement. Today we are looking at how Medicaid's long-term care rules actually work. The look-back period, estate recovery, and the legal structures families use as part of long-term planning. Let's look at what the official data actually shows, starting with the single most important distinction in this entire topic. The difference between what happens while someone is alive and what can happen after they pass away. Many people assume that entering a nursing home and applying for Medicaid puts a family's house at immediate risk of being taken by the state. According to Medicaid.gov, the federal government's own Medicaid resource, that is not how the system works. While a Medicaid recipient is alive, their primary home is generally treated as an exempt asset for eligibility purposes, meaning it does not count against Medicaid's strict asset limits regardless of its value, as long as the recipient or their spouse has an ownership interest in it. The home only becomes relevant in a different, more limited way through something called a lien. Here's what a lien actually is, in plain language. A lien is not a seizure. It is a legal notice attached to a property that says, in effect, this property has a debt against it that must be settled before it can be sold or transferred. Or, according to the Tax Equity and Fiscal Responsibility Act of 1982, a federal law that gave states this option, a state may place what's called a TEFRA lien on a Medicaid recipient's home, but only under a specific condition. The recipient must be permanently institutionalized, meaning they are in a nursing facility and not expected to return home. Even then, according to Medicaid.gov directly, a state cannot enforce that lien, meaning it cannot force a sale if any of the following people still live in the home: the recipient's spouse, a child under 21, a child who is blind or disabled at any age, or a sibling who has an ownership interest in the home and lived there for at least 1 year before the recipient's nursing home admission. That detail matters enormously, and it's worth restating plainly. As long as a protected family member is living in the home, the state cannot force its sale through a lien, full stop, according to federal Medicaid rules. This is where the second part of the system comes in, and it's the part that actually accounts for the fear most families have: Medicaid estate recovery. Here's how it actually works. Federal law, specifically the statute found at Title 42 of the U.S. Code, Section 1396P, requires every state to attempt to recover certain Medicaid long-term care costs from a recipient's estate, but only after that recipient has passed away, and only through the probate process, or in about half the states, through what's called expanded recovery that can also reach certain non-probate assets like jointly held property. According to the National Council on Aging, after a Medicaid long-term care recipient dies, a family member typically receives a formal notice from the state describing its intent to seek recovery, and the process operates similarly to any other creditor's claim against an estate. Here's why this matters in plain language. There is no Medicaid coming to take the house scenario while a parent is alive, and there is no surviving spouse, minor child, or disabled child still living there. The actual mechanism is a claim filed after death against the estate, generally limited to what Medicaid specifically paid for long-term care, not an open-ended seizure of all family wealth. There are also federal protections built directly into this system that often get left out of more sensational coverage. According to Medicaid.gov, States are flatly prohibited from pursuing estate recovery if the deceased recipient is survived by a spouse, by a child under 21, or by a child who is blind or disabled at any age. That protection lasts for as long as that protected person is alive, even if it means recovery is permanently barred in practice. States are also federally required to establish a process for waiving recovery entirely in cases of undue hardship. Although, importantly, each state defines undue hardship somewhat differently, according to multiple state-level elder law resources reviewed for this video. One more detail worth knowing precisely because it varies significantly by location. According to 2026 figures compiled from multiple Medicaid planning resources, most states currently set a home equity limit of approximately $713,000 for Medicaid eligibility purposes, with some higher cost states allowing up to roughly $1,069,000. If a home's equity exceeds that limit, it can affect eligibility even though the home is otherwise treated as exempt. This is precisely the kind of detail that varies enough by state that a single national number should be treated as a general reference point, not as the figure that applies to your specific state. Those are the facts about what happens to a home and an estate. Now, let me give you the context that most of what you've seen doesn't include. Why a 5-year look-back period exists at all, and exactly how it's calculated. Many people assume Medicaid simply checks your bank balance on the day you apply, and that's the end of the financial review. According to federal Medicaid rules, that assumption is incomplete because Medicaid is what's called a means-tested program, meaning it's designed specifically for people with limited income and assets. The federal government built in a mechanism specifically to prevent applicants from giving away money or property right before applying, solely to appear poorer than they actually are. That mechanism is the look-back period. Here's how it works, mechanically, according to the statute and the federal guidance built on it. When someone applies for nursing home Medicaid or for a home and community-based services waiver, the state Medicaid agency reviews that person's financial transactions for the 60 months, 5 years, immediately preceding the application date, according to multiple cross-confirming Medicaid planning resources. That 60-month window is the standard in 49 states and the District of Columbia. There are two notable exceptions. California currently uses a shorter window that is itself in transition under a multi-year phase in process beginning in 2026, and New York applies the standard 60-month look-back specifically to nursing home Medicaid, while its home care equivalent program currently has no look-back period at all, according to the most recent state-level guidance reviewed for this video. Because state rules shift and several states have rule changes actively in progress as of 2026, this video is describing the general federal framework. Confirming your specific state's current rules with that state's Medicaid agency or an elder law attorney is essential before relying on any of these figures for your own planning. Here's the part that often surprises people. This review does not just look for outright gifts. According to the look-back rule, any transfer of an asset for less than its fair market value during that 60-month window can be scrutinized. That includes selling a car to a family member for far below its actual value, or transferring a portion of home ownership without receiving fair payment in return. Now, here's exactly how a penalty actually gets calculated when a transfer is found to violate the look-back rule. According to the standard formula used across nearly every state, the Medicaid agency takes the total dollar value of the improperly transferred assets and divides it by what's called the state's penalty divisor, generally the average monthly cost of nursing home care in that state. In The result is the number of months the applicant becomes ineligible for Medicaid's long-term care coverage. To make this concrete, if a hypothetical applicant gave away $100,000 within the look-back window and their state's penalty divisor is $10,000 per month, the formula produces a 10-month penalty period, 10 months during which the family would need to pay for care entirely out of pocket, according to this standard calculation method used in the sources reviewed for this video. Let's slow down for a moment because one detail about timing trips up a lot of people, and it's worth being precise about it. The penalty period does not begin on the date of the improper transfer. According to Medicaid's rules, it begins on the date the person would otherwise have become eligible for Medicaid, meaning the clock on the penalty doesn't even start running until the person has actually applied and would otherwise qualify. This is a critical distinction. Making a disqualifying transfer and then waiting doesn't necessarily help because the penalty clock often doesn't start until you're already in the position of needing care and applying for assistance. Here's why this matters in plain language for understanding the only state exception that matters. Transfers made before the 60-month window even begins are not penalized at all, according to every source reviewed for this video. That single fact that the look back has a hard edge and that anything outside that edge is simply invisible to the review is the entire reason early multi-year planning exists as a field. It is not about hiding assets. It is about the federal rule itself drawing a specific line in time. And a transfer made before that line was ever drawn around your specific situation is never reviewed. This is the part most coverage of this topic gets wrong by oversimplifying in one direction or the other. Some content treats the look back as an unbeatable wall, and other content treats it as something you can quietly route around at any time with the right paperwork. Neither is accurate. The look back period is a fixed mechanical rule with a specific time frame, specific exemptions written directly into the statute, and a specific and unforgiving penalty calculation for transfers that fall inside it and don't qualify for one of those exemptions, which is exactly what comes next. This is the part most discussions of this topic skip or oversimplify into a checklist. The actual legal structures that exist within this system, and specifically how each one works on a mechanical level. I want to be precise about what this section is and isn't. This is an explanation of how these tools function using publicly available information from elder law sources and federal rules. It is not a recommendation that any specific family use any specific tool, and it is not a substitute for an elder law attorney evaluating your specific state, your specific assets, and your specific timeline. This affects different families in different ways, depending on where they sit relative to the 5-year window. So let's walk through 3 categories of statutory tools in order of how directly they're written into federal law. The first category, transfers that are exempt from the look-back rule entirely by statute. According to federal Medicaid rules, several specific transfers can be made at any time, even within the 60-month window, without triggering a penalty, because Congress wrote them directly into the law as exceptions. The most significant is the spousal transfer exemption. Assets can be transferred to a spouse without limit because Medicaid treats a married couple's assets as jointly owned regardless of whose name is on them, and a healthy spouse remaining at home is protected by something called the Community Spouse Resource Allowance, which in 2026 allows that spouse to retain up to approximately $162,660 of the couple's combined assets in most states, according to multiple Medicaid planning resources, while the applying spouse's own asset limit remains far lower. A second statutory exemption covers transfers to a child who is blind or permanently disabled of any age made specifically for that child's benefit. A third is what's commonly called the caregiver child exemption. A home can be transferred to an adult child without penalty if that child lived in the home for at least 2 years immediately before the parent's nursing home admission and provided care that, according to the documentation required by the state, allowed the parent to remain at home rather than move into a facility sooner. A fourth is the sibling exemption. A home can be transferred to a sibling who already holds an ownership interest in it and has lived there for at least 1 year before the applicant's nursing home admission. Here's why this matters in plain language. These are not loopholes in the sense of clever workarounds. They are exemptions Congress wrote directly into the statute with specific factual conditions attached to each one. Qualifying for the caregiver child exemption, for instance, generally requires documentation, sometimes a physician's statement, establishing that the care provided genuinely delayed nursing home placement. Each of these has been litigated and clarified over decades, which is precisely why getting the documentation and timing right typically requires an attorney familiar with your specific state's implementation of these federal exemptions. The second category, the Medicaid Asset Protection Trust, often abbreviated MAPT. Here's how this tool actually works mechanically. A MAPT is an irrevocable trust, meaning that once assets are placed into it, the person who created the trust generally cannot take them back out or directly control them again. Because the assets are no longer legally the applicant's own property, they are not counted toward Medicaid's asset limits once the look-back window has fully passed. And this is the single most important mechanical fact about this tool, repeated because it's the part most often misunderstood. Funding a MAPT is itself considered a transfer for purposes of the look-back rule. It does not bypass the 5-year window. It is subject to it. According to elder law sources reviewed for this video, a trust must generally be established and funded at least 5 years and 1 day before a Medicaid application for the assets inside it to be fully protected from the look-back review. If care is needed sooner than that, the trust does not help with the portion of the look-back period that hasn't yet elapsed. This is the detail that makes loophole the wrong word for this tool entirely. A MAPT is not a way to avoid the look-back period. It is a long-term planning tool that only works if it is set up well before a crisis, specifically because it has to survive the exact same 5-year clock as everything else. Used early with professional guidance, it is a recognized and commonly used estate planning instrument. Used in a crisis with care needed in months rather than years, it does essentially nothing to change near-term Medicaid eligibility, and in fact creates the same penalty period exposure as any other uncompensated transfer would. The third category, tools designed specifically for situations where there is little or no time left to plan 5 years in advance. According to multiple Medicaid planning resources, these include Medicaid-compliant annuities, which convert a lump sum of countable assets into a stream of income, and irrevocable funeral trusts, which allow a fixed, often modest amount to be set aside for funeral and burial expenses without counting against the asset limit. Neither of these requires a 5-year runway, but both have specific state-by-state rules about structure and amount that must be followed precisely, and getting the structure wrong can itself trigger a transfer penalty rather than avoid one. Here's the thread that connects all three categories. All Every single one of them is governed by exact statutory language, exact timing requirements, and exact documentation standards that vary by state. None of them is a generic script that applies the same way to every family. That is precisely why every source reviewed for this video, including Medicaid.gov itself, points families toward a certified Medicaid planner or an elder law attorney rather than toward a do-it-yourself approach. This is not political commentary, and it is not financial advice. This is what the structure of the system itself implies for 3 different planning timelines. Scenario A, planning 5 or more years before care is likely needed. This is the timeline in which every tool discussed in this video is fully available. A Medicaid Asset Protection Trust funded today, for instance, would clear the look-back window entirely on its own schedule, assuming no care need arises before that 5-year and 1-day mark. According to elder law sources, this is consistently described as the most flexible and lowest risk timeline for working with an attorney to structure a long-term plan. Scenario B, planning with a partial window, roughly 1 to 4 years before an anticipated care need, often prompted by an early diagnosis or a spouse's declining health. In this scenario, a MAPT funded today would not be fully protected by the time care is needed, but partial planning is still meaningful. The portion of the look-back period that has already elapsed by the time of application is no longer reviewable, and the statutory exemptions described earlier, particularly the spousal transfer and caregiver-child exemptions, remain fully available, regardless of how much advance time exists, because they are not 5-year dependent in the same way a trust is. Scenario C, a sudden care need with effectively no advance planning window. For example, a stroke or a sudden diagnosis requiring nursing home placement within weeks. In this scenario, according to multiple elder law resources, the tools available shift toward Medicaid-compliant annuities, spend down strategies that don't involve transfers to other people at all, and applying for the same statutory exemptions described earlier if they apply to the family's specific situation. According to these same sources, crisis planning is real, it is commonly done, and it typically still requires an attorney, precisely because the margin for error is much smaller when there's no 5-year cushion left to absorb a mistake. I am not assigning numerical probabilities to which scenario applies to any individual family, because that depends entirely on health circumstances that no general video can predict. What I can tell you with confidence, based on the structure of the rules themselves, is that the available legal tools narrow considerably as the available planning time shrinks, which is precisely why every elder law source reviewed for this video describes earlier planning as preferable to later planning, not because later planning is impossible, but because fewer tools remain fully available. Here are the specific markers to watch, since both federal and state rules in this area are subject to ongoing change. At the federal level, watch congress.gov for H.R. 6951, the Stop Unfair Medicaid Recoveries Act, introduced in January 2026. This bill would repeal the federal mandate requiring states to operate estate recovery programs and would require states to withdraw existing property liens within 90 days. As of this writing, it remains pending in the House Committee on Energy and Commerce and has not passed. This is a bill to track, not a change that has occurred. At the state level, watch your own state's Medicaid agency website directly, since several states have rule changes actively in progress as of 2026. California's look-back period, for instance, is in the middle of a multi-year phase in process, and home equity limits, the community spouse resource allowance, and other dollar figures are adjusted periodically and vary by state. And for any family actively considering one of the tools described earlier, the most useful single marker to watch is simply your own calendar relative to a potential care need, because, as this video has explained, the 5-year clock is the mechanism nearly everything else depends on. Before I let you go, here is what you can actually do with this information. And I want to be specific about which of these steps you can take yourself and which genuinely require a professional. First, something you can do yourself. Check your own state's specific Medicaid rules directly. Every state Medicaid agency publishes its current look-back period, asset limits, and home equity limit on its official website. Searching your state plus Medicaid long-term care eligibility will generally take you directly to it. Second, something you can do yourself. Begin gathering your financial records now, regardless of when you think care might be needed. According to multiple Medicaid planning resources, having clear documentation of major transactions over the past several years, bank statements, records of any gifts or transfers, and documentation of any caregiving arrangements makes any future application process significantly smoother, whether or not you end up needing any of the specific tools described in this video. Third, something that requires a professional. If you are considering any transfer of assets, any trust, or any annuity specifically with Medicaid eligibility in mind, locate a qualified elder law attorney before taking action. The National Academy of Elder Law Attorneys, commonly known as NAELA, maintains a searchable directory at NELA.org, and many state bar associations also maintain elder law attorney referral directories specifically for this purpose. Fourth, if a family member has already entered a nursing home or applied for Medicaid, and you've received a notice about a lien or estate recovery claim, contact an elder law attorney promptly rather than responding on your own, since these notices typically come with specific response deadlines and procedural requirements that vary by state. I am not providing financial, legal, or tax advice. These are official resources and a starting point for finding qualified professional guidance specific to your situation. Here's the bottom line. Medicaid cannot take a living recipient's home while a protected family member resides there, and estate recovery after death comes with specific federal protections already built in: spousal protections, dependent child protections, and a required hardship waiver process. The 5-year look-back period is real, it is mechanical, and the legal tools families use around it, statutory exemptions and properly timed trusts, work specifically because they respect that same 5-year clock, not because they get around it. None of this is a script to follow on your own. It is a real technical system, and the most reliable advantage available to any family is simply understanding the actual rules early enough to plan with a qualified attorney. If you are helping a parent think through long-term care costs, or if your own family has real estate or savings you'd like to understand better, consider sharing this video with whoever in your family is closest to that planning conversation. I'm Michael Bennett. Thank you for watching Retirement Watch, helping seniors understand their benefits.